In this lecture, we will discuss the topic of cognizable offences and non-cognizable offences under the Code of Criminal Procedure along with Indian Penal Code. Cognizable offences and non-cognizable offense. As per the definition given in section 2, clause C of the Criminal Procedure Code, cognizable offense means an offense for which, and cognizable case means a case in which a police officer may, in accordance with the first schedule or under any other law for the time being in force, arrest without warrant. So cognizable offense means an offense for which a police officer may arrest without warrant. Warrant which is to be issued by the court. So police officer may arrest without warrant in case of cognizable offense. And as per the definition given in section 2, clause L of the Criminal Procedure Code, non-cognizable offense means an offense for which, and non-cognizable case means a case in which a police officer has no authority to arrest without warrant. So non-cognizable case in which a police officer has no authority to arrest without warrant. The Criminal Procedure Code has not given any guideline to determine whether a particular offense belongs to one category or another. It all depends upon whether it is shown as cognizable or non-cognizable in the first schedule of the code. So, for the purpose of this classification of offences, either as cognizable or non-cognizable, what criteria or what guidelines are there, it is not expressly mentioned in the Code of Criminal Procedure. Then how to determine any particular offense is a cognizable or non-cognizable? So it all depends upon whether it is shown as cognizable or non-cognizable in the first schedule of the code. That schedule of the Criminal Procedure Code refers to all the offences under the Indian Penal Code and puts them into cognizable and non-cognizable categories. So this is a Criminal Procedure Code, and in this Criminal Procedure Code, after completion of the provisions in the nature of sections, there is a first schedule, and this first schedule is relating to classification of offences. So it is a first schedule relating to classification of offences in the Code of Criminal Procedure. So it covers all the offences which are defined in the Indian Penal Code. This is a table. Schedule means this is a table. It is a table. This table contains 6 columns. 6, first column, second, third, fourth, 5, 6. 6 columns. First column refers to that particular section under the Indian Penal Code which provide for punishment for any particular offence. Second column is a description of that offence in brief. Description. Third column is, it says what is the punishment for that offence. Third column. Fourth column is, it says whether that particular offence is cognizable offence or non-cognizable offence. So it is expressly mentioned here whether a particular offence under the Indian Penal Code is cognizable offence or non-cognizable offence. Fifth column expressly says whether any particular offence is bailable offence or non-bailable offence. And the last column, sixth column, it says by whom that particular offence is triable. Means for the purpose of that particular offence, which is the trial court, whether it is a court of judicial magistrate or whether it is a court of session. So Indian Penal Code, this first schedule to the Criminal Procedure Code, expressly mentions whether any particular offence under the Indian Penal Code is cognizable or non-cognizable. But it doesn't lay down any guideline or criteria for such classification. The logic behind such categorization in the schedule appears to be based upon different consideration. However, it might be generally stated that all serious offences are considered as cognizable. All serious offences generally are considered as cognizable. And basically, the seriousness of the offence is to be determined in relation to the maximum punishment provided for the offence. So this is a basic criteria to determine whether that particular offence is serious or not. What is that criteria? Basic criteria. What amount of punishment is provided for that offence? If punishment is more or larger, then that offence is serious. Offence is of serious nature. However, if we consider various offences, it is not the case that only the amount of punishment, quantum of punishment is the criteria for determination of seriousness of the offence. Besides, such seriousness of offence also depends upon following other factors. Many factors are there besides the punishment. What are those factors which are considered for such categorization of offence into cognizable and non-cognizable? First factor, what is the impact of such offence upon the general public? Impact of such offence, commission of that offence upon general public. Then, whether such offence affects public order or tranquility. Public order, public peace. Public order or tranquility, law and order, public peace. For this particular point, consider the example of Section 160 of Indian Penal Code. Section 160 of the Indian Penal Code. Offence of committing an affray. Committing an affray. It is punishable under Section 160 of the Indian Penal Code. What is affray? Affray is defined in Section 159. What is affray? Section 159 of the Indian Penal Code. When two or more persons by fighting in a public place disturb the public peace, they are said to commit an affray. So fighting in public place, quarrels, loudly quarreling. So what is the punishment for this offence? Affray. This offence is offence against the public tranquility, public peace. Punishment is provided under section 160 of the Indian Penal Code. It is imprisonment for 1 year. Imprisonment for 1 month, only 1 month. Imprisonment for 1 month or fine. Fine of ₹100 only. So punishment is imprisonment for only 1 month, maximum imprisonment 1 month, or fine, and fine is also maximum ₹100. So if we consider the punishment, if it is in case of imprisonment it is maximum 1 month, in case of fine it is maximum 100. So if we consider the punishment, this offence is not that much of serious nature. But code has made this, criminal procedure code has made this particular offence as a cognizable. It is a cognizable offence. Cognizable offence in the sense that here, in case of such offence, police officer can arrest the suspected offender without warrant. Then take another example. Means another criteria which may be determined for determination of seriousness of the offence. What amount of terror gets generated because of such offence? For that purpose, terror because of such offence, terror in the mind of general public, or in general terror. Take the case of offence which is punishable under section 341 of Indian Penal Code. What is that offence? Wrongfully restraining any person from going anywhere. Wrongfully restraining any person. Section 341 of the Indian Penal Code. What is the punishment? Here punishment is provided simple imprisonment for 1 month, or fine of ₹500. So imprisonment only 1 month, fine up to ₹500. So if we consider the punishment, offence doesn't appear to be much serious, but the criminal procedure code has made it cognizable offence. So it is a cognizable offence, and police officer can arrest the suspected offender without warrant. Or take another example. Offence under section 447 of the Indian Penal Code. What is offence? Offence of criminal trespass. Criminal trespass with intent to commit an offence. What is the punishment provided? Imprisonment for 3 months, or fine of ₹500. So what is the maximum imprisonment? 3 months. Then also, this offence is purposefully made as a cognizable offence under the by the Code of Criminal Procedure. It is a cognizable offence. The police officer can arrest without warrant. What are the other criteria which determines the seriousness of the offence? Whether such offence affects general administration, whether such offence affects markets and economy of the country, whether it affects markets and economy of the country. For that purpose, consider the example of offence which is punishable under section 267 of the Indian Penal Code. What is that offence? Making of false weight for weighing, making false weights for fraudulent use, making false weights. Naturally, this offense will adversely affects the markets. Making false weights for fraudulent use. What is punishment provided? It is for 1 year or fine. So punishment is maximum 1 year. Then also this offense is purposefully made as cognizable offense. So what are the other criteria for determination of seriousness of the offense? Whether it creates public nuisance or it causes great inconvenience to the public. Whether it creates public nuisance or it causes great inconvenience to the public generally. For that purpose, we can take example of an offense punishable under section 283 of the Indian Penal Code. Section 283. What is that offense? Causing obstruction in public way. Causing obstruction in public way. What is the punishment provided for this particular offense? It is a fine up to rupees 200. Fine of rupees 200. Here it is to be noted here that for this particular offense there is no punishment for imprisonment. It is merely a punishment of fine. No imprisonment, punishment of imprisonment is provided here. Merely punishment of fine, and that is up to rupees 200. What is offense? Offense causing obstruction in public way. So if we consider no imprisonment, fine up to 200, this offense appears to be a very least serious offense. Then also the Criminal Procedure Code has made this particular offense as a cognizable offense. Therefore, any such person who is causing obstruction in public way can be arrested by the police officer without warrant. What are other offences? Means, what are the other criteria for determination of seriousness of the offences? Whether such offence is against the social values or morality. Values. For that purpose, take the example of offence punishable under section 294 of the Indian Penal Code. What is that offence? Singing obscene song or doing any obscene act in public place. Obscene songs, obscene act. What is the punishment provided? Punishment is imprisonment for 3 months or fine. Maximum punishment 3 months. But since this offense is against the social values or morality, it is a cognizable offense. Take another offense, another example. Offense punishable under section 509 of the Indian Penal Code. What is that offense? Uttering any word intended to insult the modesty of a woman. Modesty of a woman. Uttering any word to insult the modesty of a woman. So what is the punishment provided for that offense? It is a simple imprisonment for 3 years and also with fine. So punishment is maximum 3 years. But since this offense is against the social values or morality, this offense is made as a cognizable offense in the sense that police officer can arrest without warrant. So we have seen here the contrast example where punishments are very less, but then also offenses are cognizable offenses. It is to be noted here that such offences under the other laws than the Indian Penal Code which are punishable with imprisonment for 3 years or more have been shown in the first schedule as the cognizable offences, and those punishable with less than 3 years have been shown as non-cognizable offences. However, this rule may also be subject to few exceptions. So this first schedule, Criminal Procedure Code, it gives the list of all those offences which are punishable under the Indian Penal Code. But offences are also defined and made punishable in various other statutes or acts. There may be various other criminal minor acts where offences are defined and punishment is provided for it. So, in case of those offences other than Indian Penal Code, in case of those offences which are defined or provided for in other act, in case of such offences, this at the end of this first schedule, it is mentioned that if it is punishable with imprisonment for 3 years or more, then it is cognizable offence, and if it is punishable less than 3 years, then it is non-cognizable offence. In case of cognizable offence, a police officer can arrest the accused person even without any warrant being issued by a magistrate, judicial magistrate, court of judicial magistrate. So, a police officer can arrest the accused person, suspected person, even without any warrant being issued by a magistrate. Besides, police can also start investigation of the case even without any directions or orders being passed by a magistrate. So, police can arrest without warrant, police can start investigation even without any order being passed by the magistrate. It is so because the offender might escape by the time the police obtain a warrant of arrest. So, why such a provision is made? If we compel the police officer for arresting the suspected offender, first obtain the warrant from the court, arrest warrant from the court. So, in between the time police obtains the warrant, offender might escape, run away. In case of non-cognizable offence, generally the police will not interfere into the matter without any order from a magistrate. So, non-cognizable offence, police will not interfere into the matter generally without any order from a magistrate. So, only upon the order of magistrate, police can see that non-cognizable offence. Thus, the non-cognizable offences are less serious compared to cognizable offence. Non-cognizable offences are less serious, even though punishment may be higher punishment. For example, if we consider the offence punishable under section 493 of the Indian Penal Code, what is the offence? A man by deceit causing any woman not lawfully married to him to believe that she is lawfully married to him, and so to cohabit with him in that belief. So, it is an offence of deceit, cheating. A man by deceit and cheating cause any woman, which woman? Who is not lawfully married to him. What he caused to believe that woman that she is lawfully married to him. What is the purpose of causing such belief in the mind of such woman? To cohabit or to have intercourse with that woman in that false belief. So, this is the offence punishable with the imprisonment for 10 years and fine. What is the punishment? Imprisonment for 10 years and fine. So, if we consider the amount of punishment of imprisonment it is very large punishment, very big punishment, then also this particular offense is non-cognizable. Non-cognizable, it means that without any order from the magistrate, police officer cannot arrest the suspected offender, police officer cannot start investigation into such offense without the order of the magistrate. So it is a non-cognizable offense. Section 493 of the Indian Penal Code. As per the subsection 2 of section 155 of the Criminal Procedure Code, section 155 subsection 2, when the offense is such which is non-cognizable, then police officer cannot investigate into it without the order of a magistrate. So, for the purpose of causing investigation, starting investigation for non-cognizable case, non-cognizable offense, police officer needs to obtain order from the court of magistrate. Without order from the magistrate, police officer cannot start investigation into non-cognizable case. Sometimes a single offense may include several offenses. So when all the offenses are non-cognizable, then it is a non-cognizable case. However, if at least one or more of such several offenses is cognizable, then it will be a cognizable case. So, the incident of a commission of crime, incident, event, there may be several things are done in commission of such crime. So, in those from such several things, various different offenses get constituted. Various different offenses as defined under the Indian Penal Code get constituted. So, by such a single event or incident of crime, when several offenses get constituted and when all such several offenses are non-cognizable, then it is a case of non-cognizable case. But even a single offense is cognizable. For example, take 5 offenses get constituted from that incident of crime. Out of that 5, 1 is cognizable, 4 is non-cognizable. Then in that case, such case is treated to be a cognizable case. It means that police officer can arrest the suspected offender without warrant, and police officer can start investigation even without the order of magistrate. In the case of cognizable offense, it appears to be the responsibility of the state to bring the offender to justice. Responsibility of the state, because cognizable offenses are considered to be of more serious nature. It affects the society in large. So even though the victim of that particular cognizable offense may be a single person, then also it is considered that that offense has been committed not against only that single person who is a victim, but it is against the society. Offense is against the society, therefore it is the responsibility of the state. State in the sense it is a country, nation. It is the responsibility of the state to bring the offender to the justice. And who are responsible on behalf of the state to bring the offender to justice? It is the police. Therefore, in case of cognizable offense, police officer who are representing the state arrest the suspected offender without warrant. Then after completion of evidence, when trial gets started in the trial court, it is the public prosecutor who prosecutes the matter on behalf of the state. Subject to few exceptions, the non-cognizable offences are generally considered more in the nature of private wrongs, and therefore the collection of evidence and prosecution of the offender are left to the efforts and initiative of the private citizens to whom damage or injury have caused because of such non-cognizable offences. So, non-cognizable offences are generally considered as private wrongs, subject to few exceptions. Therefore, in such cases of non-cognizable offence, the person who is a victim of that offence or who has suffered some damage or injury because of commission of such offence, he has to make a complaint, formal complaint, to the court of magistrate, and then only the court of magistrate can take the cognizance of such offence, and if the magistrate thinks it necessary, then the magistrate may direct the police to make investigation into such non-cognizable offence. So generally such non-cognizable offences are more in the nature of private wrongs. Therefore the collection of evidence, prosecution of the offender are left to the efforts and initiative of the private citizens to whom damage or injury have caused because of such non-cognizable offences. So we have considered this topic of cognizable and non-cognizable offence. So in the next part of the video lecture series, we will consider some another topic under the code of criminal procedure. Thank you.